The webinar today is titled 2016 ASCA Ethical Standards for School Counselors, and we are happy to be joined by our presenter, Carolyn Stone. Carolyn Stone is a professor at the University of North Florida and chair of ASCA's Ethics Committee. She is the author of School Counseling Principles, Ethics, and Law. Welcome, Carolyn.
Thanks. Thank you so much, Jen, and welcome everyone who's on the webinar. This is near and dear to my heart because I've had the honor of being involved with the last 3 revisions of the ethical standards, and this revision I think will be institutionalized. Our approach to this revision, I'm hoping it'll be institutionalized from here on out. What we did this time, which was so different from the others, is we in the past had a committee of 5-6 people, and then we opened it up for a public comment period, and then delegate assembly always weighed in and gave us very good feedback, and then we blessed it at delegate assembly once all the feedback came in. This time, however, we started over a year ago at the 2015 delegate assembly, when we charged all of the 50 state delegates to go back and develop in their home state some kind of committee or approach to revising the codes. So we had all 50 states working out there to develop a system to revise the codes. We got feedback from all 50 states about what that system would be, and 38 states actually sent us a revised set of ethical standards. We took all that information, we collapsed it into one document, and then we sent it out to state leaders across the nation. They then took a second blush at this very lengthy document, and we further refined, and then we sent it out to a public comment period with some more work in between. But basically it hit the public comment period in pretty good stead after so many professionals had taken a look at it. The public comment was then followed by presentation at the 2016 Delegate Assembly, and what you have now is your Code of Ethics. Code of Ethics matter. They matter a great deal because you can lose your job based on stepping on your Code of Ethics. That's how much they mean to our profession. In fact, the definition of being a professional is that you have a ethical code. Our ethical code has been in existence for quite a few years. 1984, I believe, was our first one. And that's impressive. You would think that everybody's always had an ethical code. Not so. I'm involved as part of a member of a think tank trying to put together ethical codes for teachers. So it's new. It's new for some professions. When we talk about an ethical code for school counselors, we all know what we're talking about because it is part of the fabric of our profession. Ethics, they're aspirational. It matters not that you've been legal. You also must also try to be ethical. Being legal is pretty easy. It's more black and white. Being ethical takes more work and judgment on our part. So we do our due diligence to try to make sure that we're not only legal, but we're aspirational. Of course, when the two ethics and law bump into each other, the law supersedes, but that does not mean that we dismiss our ethical imperative. We're always trying to make certain that we do both. And we have some cases, court cases, where the counselor was exonerated and they were held, they were held that their actions were technically legal, but the profession would still worry that there might have been a different way the counselor could have gone. Again, that aspirational piece. The preamble for our ethical codes, it's really important. It sets the tone. We changed the preamble this time because in the past it was too narrow who the codes were meant for. This time the wording has changed that it not only supports school counselors, but it's for interns, school counseling directors and supervisors, and for counselor educators. We will work on a school counselor educator code of ethics, but as an educator, as a school counselor educator, these codes matter. They are part of our ethical imperative. The preamble was also changed to talk about equity again. We changed the 2004 codes to really beef up the equity piece. The 2010 codes, we enlarged on it. The 2016, we enlarged on it again because that is who we are. We are social justice. We should be that person under the schoolhouse roof that is the social justice lion, the one that's looking to see where are kids being supported, where are pockets of kids, their opportunities are being stratified. So the equity piece is a big part of our ethical imperative. It's no longer just the right thing to do based on a person's personal beliefs. It is the ethical thing to do based on your position as a school counselor. The purpose statement was changed and wording added that, again, in consultation with others, this is how we changed our ethical codes, and I'm really proud of how many member voices were put into the code. Responsibility to students is always front and center. That and the confidentiality imperative is always front and center. What was added this time is more about brief therapy, working with students in a brief context. There are some external forces that want to pigeonhole school counselors and into one very narrow role, that of a clinician, a therapeutic. By putting somebody on an IEP every single week for the entire year, you're basically boxing them into a therapeutic role, even if it's if what we're doing is social skills with the student. So we're trying to push back on having somebody take away our comprehensive, powerful role as a school counselor. We do not diagnose, if you'll see that letter C. And again, the letter B talks about the brief context in which we work with students, and if they need long-term, like an entire year, an entire school year, that is outside our ethical purview. So use your ethical codes if somebody's trying to box you into a narrow role. We also changed in responsibility to students' sexual orientation, gender identification, and I don't need to explain that because with the media and what is happening in society today, we are seeing in schools a greater need to put in the forefront what is the school counselor's role in helping to respect and support transgender students. And again, the sexual orientation has been there before, but we've increased it in a number of areas. Confidentiality is always going to be an issue. We're always struggling to work with the grays of doing our job. There is no black and white approach, thank goodness. Wouldn't that be a terrible place to be as a school counselor if every time a child walked through the door and they told you what their issue was, you had some lever you had to pull to see what your response had to be? That would be a terrible injustice for the profession of school counseling and the very basis of what we're about, which is to be able to look into each kid's eyes and figure out, what do I need to do for you on this day? So we try, codes are changed, we try to beef up the confidentiality imperative and our ability to support students' confidences, our ability to make certain that we don't step on them, but at the same time recognizing they're in a setting called schools and parents have rights. So that's that tug of war you feel on a daily basis, isn't it? You know that this student has a right to the trusting relationship. Yet on the flip side, they're in an academic setting, not a setting where anyone put their child on the bus for counseling, and that you're going to always have that confidentiality tug of war. This whole section, A3, is brand new, and I'm very, very proud of membership for making it known that this was a big gap in our ethical codes. When we put this out there for the 50 states to weigh in, one of the number one things that came back was, where is the data-informed practice section? Well, it wasn't there. We had a few references to it, but this entire section is to the 2016 codes. What does that mean for us? That means that it can't be just something we try to figure out how to do. It means that we are responsible to look at student data and to know the goals of our school counseling program should revolve around what are the gaps, who's being left behind, what's not matching up, are my kids' opportunities being diminished because of system barriers. So the whole data-driven piece was added. This is another big change in the academic, career, and social-emotional plans. A whole new beefed up section on college career plans was developed. And this is, I think, critically important in our society today, because any of the research that you look at, we still have gaps in income, especially children who are in families whose income is less than $25,000 have a less than 5% chance of ever graduating from college. Because part of the reason is the information gap that exists when somebody is in a state of constant trying to make ends meet, trying to help their child negotiate the college and career process. Plus, how many parents, even affluent parents who have a college education themselves, can negotiate the college admissions process without a whole lot of research on their own part? So we know that this is our very best tool as school counselors to level the playing field for kids. So much was added on the college and career piece. We wish we didn't have to constantly come back to the managing boundaries and the dual relationship, but we are, in our profession, we still have people who commit boundary violations. We recognize and honor that boundary crossings are necessary. They're absolutely necessary. We can't come to our profession with it being a one-size-fits-all. We can't say, well, I can't do that for this student because it wouldn't be fair to the 529 others that I have. Our profession is built on context. Sometimes justice means you do more for one student over another. But what we have to ask ourselves constantly when we cross a boundary, what are the good and bad consequences for kids and for our own professional identity and our professional reputation? So we just put more information and more language in there about what you have to do when you cross a boundary, how you have to try and manage those boundaries. Because a boundary violation can't happen without a boundary crossing. So we recognize that boundary crossings are critically important but have to be managed. we talked, again, we expanded on the referral because, again, our role is comprehensive. It can't be us one-dimensional, and we need our agencies and others that we need to collaborate with when additional student assistance is needed. We also have to be careful that we don't endorse one over another, that we put the facts out there and stay neutral, because we have some court cases which often give us guidance in how to develop our ethical codes. We have some court cases where counselors oversold one counselor over another, and when the counselor took their child into his own home under residential treatment, which was not so because there was no residential treatment, and sexually abused her for 10 weeks, that became a lightning rod for us, that we need to put disclaimers on our list that we give out to parents, that they really need to follow their own instincts about whether or not this person is a match for their child. So again, just that word of warning, not to endorse one over another. This new standard, A6E, came about as a result of the Ward versus Wilbanks court case, and I'll come back to it in just a minute. Ward versus Wilbanks, this was a court case that happened a couple of years ago where Julia Ward was a student in school counseling at Eastern Michigan University. She was asked to counsel in the counseling center on the campus. She got the intake form for an adult student on the campus, and he wanted to work on same-sex relationships. She gave that back to the director and said, "I'm sorry, I can't work on same-sex relationships. It's against my religious beliefs." When they brought her in for an improvement plan, she also informed them that she couldn't work on any topic that included abortion, because abortion was against her religion, nor would she work with students on the issue of having sex out of wedlock, because that was against her religion. When the lower court got the case, they said, "Wait a minute, profession. You've said you can refer." Julia Ward said she would refer. So which is it? Does your profession believe that you can refer, or do they think that you should be able to work with all students? We changed the ethical codes to read thus. They say refrain. Refrain from referring based solely on your beliefs or values. If it is a competency, please refer. You shouldn't be, according to your ethical code, you shouldn't be working outside your competence level. However, if it is a personal belief or value, caution, refrain from referring based solely on your values. Values that are rooted in your religion, culture, ethnicity, or personal worldview. Absolutely, you're entitled to your religious beliefs. You're entitled, of course, to your culture and your worldview. But what we learned from the Ward case, and what the American Counseling Association learned, is that our ethical codes didn't really have any language that had enough teeth to support Eastern Michigan University and to say to the profession, wait a minute, we all need to seek training and supervision in areas where we are at risk of imposing our values on that student, who, by the way, is mandated to go to school. So here you have a student client mandated to be in your setting. We can't impose our worldview, our religious values on this vulnerable 13-year-old and say to that 13-year-old, gee, sure would like to help you, but I believe you're going to burn in hell if you don't change your ways. That's a bit of an exaggeration, but you know what I'm trying to say. The onus is on us to protect our religious views, but at the same time protect our professional views by being able to affirm every student in our charge. We have to be able to look into that kid's eyes and affirm affirm them. Even if we can't affirm a child's behavior, we have to be able to affirm them. So the 2016 standards followed the lead of the American Counselor Association also, in that we changed our ethical codes. That next court case that hits, we actually have some language here on which the profession can stand, because the Ward case was appealed to a higher court, and the higher court judge said, no, you need to, a jury trial needs to happen for this case because your profession has said you can refer. Okay, well, we did have that. Now we've tried to qualify it a little bit. So that's how some of the codes come to change, is when we have court cases that give us guidance, and we know when we have those court cases, we run to our codes and say, what do the codes say? Would they be a help? Would they be a hindrance? Again, collaborative relationships with referral agencies, and you know, just some things about when you work with those agencies, they should request a sign of, you should have an assigned form that you can release information. More about appropriate referrals. Group work. There's some new language in group work. We have a new edition that says facilitate short-term groups. In other words, I don't know that there's any counselor out there who has time to run a group for the same 7 kids for the whole year. What we're saying is best practice, facilitate short-term groups. Again, your brief counseling approach. Also, the duty to inform parents, it was best practice before. Now it's inform parents. When you put their child in a small group, you're doing something dramatically different than what they put their child on the bus for. So they're just simply saying, inform parents. You don't have to get a written unless your district says so, but you need to at least let them know, because you are doing something quite different from what they thought their child was going to be doing when they went to school. The group work also talks about use data. That's a new, an entirely new tenet there. Use data to measure members' needs so that you have well-defined expectations and you know where you've been. Again, that data-informed practice. Is it attendance you're working on? Is it discipline referrals? Are you trying to help these kids be more successful students? Would it be grades? And other new additions, evidence-based, research-based practices, and measure your outcomes. Okay? Student peer support, new wording, again to safeguard students who are receiving peer support and students who are giving peer support. So that change was made. Also, we moved from clear imminent danger to serious and foreseeable harm. Actually, we moved from that back in 2010, as did the American Counseling Association, because we all recognize that clear imminent danger is too strict a barometer. We needed to be able to exercise judgment at a much earlier point. You don't wait till the knife is poised over the heart to call parents. We have to be able to use judgment that when something is serious and foreseeable, that we have a chance to intervene and use our judgment about whether or not parents should be called. School counselors are a very special group of folks who have good gut, who exercise good judgment, and we don't want policies that tie our hands. We want to be able to look at a student's situation in context and decide whether or not it is time to call parents. However, when you have a student who is in danger, we have to intervene on behalf of a child when the consequence is so great. Even if it's a relatively remote chance of suicide, for example, we call parents. We err on the side of caution. Better to be wrong and we caused a lot of upset than to not call and be wrong and death of a child. So that was some new wording in place about using risk assessments with caution. Risk assessment shouldn't be used to negate a risk, because how do we really know? If we have to give a level, we avoid saying we don't think this child is at risk, because how do you know? If this child was at risk enough to warrant an assessment, then they're at risk enough to call parents and let them know that an assessment was done and they need to seek further help for their child. Because again, we have too many incidences and cases where kids fooled us once it was on their radar that we were onto them and that they may have their plans thwarted. They tell us what we want to hear. So again, language was put in to beef up the fact that when a child is in danger, we don't release them. We stay with that child until we can put them in the care of parents or guardians. Not we necessarily, but school officials. Somebody needs to support that child and stay with them until we can safely put them in protective custody. Underserved and at-risk students. This is an entirely new section. It's new to the 2016 codes. Again, trying to beef up that equity piece where we're looking at children who need, again, it's not a one-size-fits-all, children who need more. On the other flip side, it's not we should be there for 5% of our population. We need to be there for 100% of our population in a comprehensive school counseling program. But it is a new section on giving us some ethical language to help us when we want to be that voice of social advocacy, when we want to be that voice that says, wait a minute, are we really doing a service to this student, you know, when we disallow them to take the rigor courses they want. That social justice voice that levels the playing field. Another brand new section is the section on bullying, harassment, and child abuse. This section is new. We have always, you know, had a few tenets that say you always, you know, call in child abuse, etc. But we've tried to, again, heighten the awareness and the ethical imperative to make certain that we know what Title IX says, that the Office of Civil Rights, who governs Title IX, they give school counselors a lot of credibility and a lot of credit into being sometimes the first outcry for these kids who are being bullied, kids who are victims of dating violence, kids who are being sexually harassed. We all know about how often we're the ones that are brought the child abuse reports by teachers who also should be calling it in. But this section helps us forward our role as advocate, and it just, again, Title IX has been redefined and it continues to be redefined by the Office of Civil Rights, who create what they call these Dear Colleague letters, which give us guidance on how we behave as school counselors and as education officials. So use your Office of Civil Rights and Title IX legal muscle. It's your very best federal statute, aside from the Family Education Rights and Privacy Act, which is also another very strong, wonderful statute that helps us protect kids from discrimination. So by all means, use your Title IX legal muscle and your ethical codes, which have beefed up the bullying, harassment, and child abuse sections. Student records. Student records were updated Just again to underscore that we don't want to work our way around FERPA, Family Educational Rights and Privacy Act. We want to be those folks under the schoolhouse roof that celebrates and promotes FERPA. FERPA is a good law. It protects parents' right to review and look at their child's records, and also to challenge inaccuracies. So we want to be that advocate that makes sure that we are respecting FERPA. We are also not trying to work our way around FERPA when it comes to our own notes that we keep on kids. Because if you maintain something on a child, it's very hard to make it a sole possession record. And if it's maintained on a child, parents have rights to it. We also did a lot on student records because of electronic records now. We have beefed up some guidelines on shredding sole possession records and electronic sole possession records. So that's part of the ethical code. Take a look at A12, E, and F. We can't be all things to all people. We certainly can't demand that the district have proper encrypted case notes, educational records. But we can be that voice of reason and that voice when somebody's asking something on a mainframe that is highly sensitive information, and how do we respect the district's right to decide what is kept on a child and educational record, because they have a right to decide what is kept in an educational record. We have to be able to respect their right to do that, but at the same time advocate for our own confidentiality and advocate that sensitive information is not passed willy-nilly from hand to hand, and that if anybody is going to demand that we put it on an electronic communication, it is handled in such a way that only the very, what they call, you have, oh my gosh, it's slipped right out what FERPA calls it. Anyway, sorry, LEI. They call it legitimate educational interest. That only people with legitimate educational interest to know what you wrote down, that only those people can get it. Yeah, technically, a lot of people have LEI, but LEI is defined by your need to know certain pieces of information. So even though the teacher has LEI for all the students in her class, she really shouldn't have LEI for your case notes if this doesn't involve any of her students. And it's not a given that she should have LEI for even somebody in her class if it is information that should be, again, respected and kept confidential. The onus is unfortunately on school counselors to work with the district and help the district understand about sensitive information, because the Family Educational Rights and Privacy Act, the FIPCO, the Family Policy Compliance Office, who governs FERPA, says to us, you don't have to keep educational records, but if you do, here are the rules. And if you do keep educational records, you can decide what's in them, but here are the rules. So LEI. A13 is Evaluation, Assessment, and Interpretation. Again, new addition, only use valid and reliable tests and assessments, and be concerned about bias and cultural sensitivity. Some minor language changes went into that section also. Another new addition, multiple data points when possible, to provide families and students with accurate, objective information. And also, best practice conduct school assessment, school counseling program evaluations to determine if your program is meeting a comprehensive school counseling program. Much was changed about digital citizenship. We have so far to go in this area. It changes daily. We can't keep up with it. Trying very hard to keep up with it, and we might have to go from changing our codes every 6 years to changing our codes every 3 years just to keep up with the technical and digital citizenship. But please read that section. Again, we can't be all things to all people, but we are trying our very best to figure out how to protect student records, especially our case notes. And then this is a new section about, has a lot to do with Facebook and other social media and how we have to maintain those appropriate boundaries when we're using social media, and again, the protection of what, who has access, how we present the information, etc. We have to have a brand new section on virtual and distance school counseling, because more and more, in fact, I want to do the research. I'm not sure that there's any state now that doesn't have a virtual high school. Some states have virtual elementary and middle schools. So we need to pay attention to this area, and it might require more of us in the future to make certain that we're doing the right thing by kids virtually. Can't say enough about B1, responsibilities to parents and guardians. We have changed quite a bit of this area. We thought we had a good one before, but thanks to all the voices that came in, we know that the addition of these codes, they were a good addition because that relationship with parents and communication with parents is critical. Responsibility to school, again, some new additions there about professional relationships and systems of communication with staff and administration to support students. Other new additions to responsibility to school. We've talked more about our systemic change advocacy efforts, our leadership efforts, our need to be culturally competent, our need for students to have a safe, inclusive school environment. Then there's responsibilities to self. We have two new sections there. We're saying that, hey, if you're going to hire someone and call them a school counselor, please, they should have completed a counselor education program at an accredited institution and have a master's degree. We had a court case recently that came out of New Jersey, and all over the documents talked about this school counselor who hadn't called parents about a child's suicide, even though she talked to the child for 4 hours about his suicidal ideation. She took it on herself to deem him not suicidal. Well, what's bad about that is all over the court documents it called her a school counselor. She had a bachelor's degree and she was not a graduate of a counselor education program. So we are trying to protect the profession by putting that in ethical codes, and that could be used in a court of law when somebody does something to not report child abuse, not report suicide, they get in trouble and they call themselves a school counselor. No, according to our ethical codes, they have not met the ethical standard of being a school counselor. Also, another new addition, that goes back to personally held beliefs and values. So refrain from refusing services to students based solely on the counselor's beliefs or values rooted in religion, culture, ethnicity. Again, that goes back to the Julia Ward case and to what we know in our profession, because we're in that very intimate, personal, eyeball to eyeball, knees to knees, that dyad that we, of all people, have to check and work on any kind of bias that will keep us from providing a comprehensive service to all students. Again, responsibility to self. We made some additional changes. Intellectual property, actions and statements. Distinction between actions and statements made as a private person and one that represents the school counseling profession. And that's hard to separate those out, and we have to ever be mindful of our behavior, even past that 45, 50 hours a week that we're on school grounds and working in that setting, place, time. Even though the place and time may change, that professionalism has to follow with us. So yeah, we can have a personal life, but we need to keep that personal life ever in the forefront, that we are wearing the mantle of I am a school counselor. We put a new section in, new additions to this section rather, on school counselor administrators and supervisors, asking, again, talking about supervisors' ethical imperative to advocate for the school counseling profession and the school counselors under their charge. So all of that is new wording about the school counseling profession, the advocacy that needs to go with if you're going to take on the role of being a supervisor of school counselors, administrator of school counselors. With it comes the imperative to be the advocate for school counselors, and also to take steps to eliminate anything that keeps that school counselor from being able to comply with their ethical and legal obligations to the profession. We added quite a bit on interns. We need to protect the future of our profession by laying out a little more what needs to happen in the training of interns, and that section is something that you'll want to look at, especially if you are a site supervisor or a counselor educator. Maintenance of standards. This section was a single statement. Now it's much more extensive and lays out the procedures that serve as a guide for ethical behavior. It highlights mandatory reporting. It lays out what to do if a behavior in question is unlawful, abusive. Specific steps to take when a matter remains unresolved. That is, a matter, a professional who is acting in an unprofessional manner. And love it, groom it, protect your role as a school counselor, and forgive yourself when you've done your due diligence and things don't turn out exactly as you had hoped. Because we are in a wonderful position in that we get to use judgment every minute of the day. And anytime you're called on to use your judgment every minute of the day, sometimes there's going to be some things that don't turn out just right. And in the words of Wesley Bridges, an attorney who was working on a case involving a student suicide, he said, in your profession of school counseling, you really can't practice risk-free. So don't be paralyzed by that. Know your codes, know your school board policies, know your laws, do your due diligence, and above all, consult, consult, consult. Seek supervision. Every court case where the judge slapped the school counselor around involved the fact that they did not consult, they didn't seek supervision. It is a basic tenet of the ethical codes, all throughout the codes. So, and again, be kind to yourself, because it is, it's a situation where we have taken on a job that is going to, by its very nature, require of us to make so many judgments that the consequences we cannot possibly predict. So, thank you for joining me. I'm now open for questions. Jen, you have some questions that came through?
I do. Let me see here. So the first question we actually received a little bit earlier before the webinar started. Let's see. It says ethical standard D, school internships B, clinical supervision. What constitutes clinical supervision?
Okay, do I have that code in front of me? No, I don't. Can you read me the question again, please?
So it comes from Ethical Standard D, School Internships B. B as in boy, and then specifically the terminology clinical supervision. What constitutes clinical supervision?
All right, very good. Clinical can take on multiple meanings. We are not saying that school counselors are clinical therapeutic purveyors of services. We are not. In fact, the ASCA model says it has two columns, appropriate and inappropriate activities, services, program components. One of the inappropriate is clinical therapeutic. However, when you are an intern out there and you are doing this job for the first time, even brief solution-focused therapy, you should have somebody guiding your practice as an intern, somebody making certain that, above all, do no harm. So I think I think that is, if I'm reading the one that you're interested in looking at, I think that's what we're talking about, is the clinical piece, if we're on the same page with the same code. The clinical piece is not, you've got to do 1,000 clock hours after you get your master's under the tutelage of a clinician who you pay to supervise you. No, it means that you can't put an intern out there and say, good luck. We have to put our interns out there with support that we need, with vetted, hand-picked site supervisors, and also with the counselor educator tuned in, paying attention, checking in, doing supervision. For example, at our university, we do the supervision 2.5 hours a week with the counselor educator, and then they get an hour a week out in the field with their site supervisor. Good question, thank you. What else do we have?
All right, we have under ethical standard A2J, protect confidentiality of students' records and release personal data in accordance. And then the distribution of emergency action plans for students to all staff. This includes picture, name, grade, teacher, diagnosis, emergency action steps, medication, parent, phone numbers. And then the question is I can understand how this can help students, but am concerned the massive information to all staff. In my prior school in a different state, this was highly protected information. Please advise. Did you get all that?
No, I didn't. I'm so sorry.
Okay, so
I am so sorry.
That's okay. I think so. I think that the root of the question is the protection of confidentiality of students' records and releasing personal data in the event of the emergency action plans for students. So basically, it sounds like, and then the person says, I can understand how this can help students, but am concerned about the massive information to all staff. And apparently, it was highly protected information in previous environments. So what is your take on that?
I hope I'm answering the question correctly. If not, please email me, whoever asked that question, at cstone@unf.edu, and I'll give you a call and we'll discuss it. But if I'm following, Family Educational Rights and Privacy Act allow schools to give out directory information. Directory information, you don't have to give out any directory information, but if you do, it is it has to do with, you know, name, address, telephone number, etc. So this is legal under FERPA. And if you're talking about safety needs of students, this might be the difference between a safe situation for a student and an unsafe situation for a student. So we're protected by federal statute to do this. I hope I got at it. If not, please call me. Please email me and I'll call you.
Okay, perfect.
I'm going to have lots of time this weekend to call people because they closed my university. We are in a hurricane right now. We are in a hurricane watch. So I'll have lots of time to talk to anybody who wants to talk to me about these ethical codes this weekend.
Perfect. All right. Is note counselor an acceptable form of note-taking for school counselors?
No counselor?
Note,
Is what?
note, N-O-T-E, note counselor, is note counselor an acceptable form of note-taking for school counselors?
That must be some kind of software program to gather information on electronically. So if that's wrong, email me and we'll talk. But it sounds like this is some kind of software program. Districts all over the country are putting in place student information management systems that are now oftentimes including a section for counselors' case notes. Many times districts are not even paying any attention to that. I shouldn't say many times because I don't know that for sure, but I do know of some incidences where districts are not requiring the counselors to put anything on the case note piece of the student information management system. However, when they do, it is their right to do so. Again, what I was talking about earlier, our right, however, and our ethical imperative is to fight for what we have to put on there. That we use codes, A for academics, for example, S for social, personal social, that we're not made to put highly sensitive information that the whole world doesn't need to know. And not that the whole world has access to those student information management, but it's just so hard to protect electronic communication today that we don't want to be able to be required to put things on a mainframe or on the management system that's highly sensitive. So yes, we have to obey the district's need to maybe keep track of how many students we're seeing and which students they are, but we want to protect the information that we're required to put on there so that it is not highly sensitive and prejudicial and discriminating.
All right, thank you. Any thoughts about teachers attending parent conferences for a student who is not on their class roster but feel they have a right to attend because they are the team leader? The setting would be in a middle school where there are academic teams.
And this teacher does not have this child at all?
It says for a student who is not on their class roster but feel they have a right to attend because they are a team.
If they teach the student for other, this is a little bit out of my comfort zone, but because I pay attention to school counselors, not the teaching ethical and legal dilemmas. But just as an opinion, if counselors are the ones that are asked to set up these conferences and a teacher is wanting to be part of it and you can't find as a counselor a good reason why you should include that teacher, then it's your judgment to say, I think you might want to make a second conference. It sounds like there might just be some conflict that's going on in that grade level or department and somebody's trying to trump somebody else. I think we ought to stay neutral. We are Switzerland. We ought to stay out of the fray of two teachers who might be in conflict. Why else would that teacher insist on being part of a conference? We have to ask ourselves, why is this teacher insisting on this? Mm-hmm. It can't be, if it's for the greater good of the student, then we can set up a separate conference for that teacher. If it's to trump another teacher, we don't want any part of that because we're Switzerland. We're not in anybody's camp.
Okay. Could you give an example of how a school counselor might use Title IX, it looks like?
Absolutely. Title IX is your very best friend, except for FERPA, when it comes to federal statutes. Title IX, for example, go on the Office of Civil Rights website, and because they govern Title IX, and look at all the Dear Colleague letters they have for us. For example, when a principal might want to out a kid as being gay to their parents, go and look at the wealth of information we have in court cases. For example, the Wynn versus Wolf court case, where a federal judge said it's not necessarily our right to out kids to their parents. And, you know, these are some of the areas where we can help by being politically savvy and not getting ourselves in a power struggle with administration. But by being politically savvy, we can take to the administration and say, look, this girl's afraid of this young man. And according to the Office of Civil Rights, we have an obligation to create a safe environment for her. We have to act, or we are against the Office of Civil Rights if we don't. And they can, a suit can be filed against us, not a suit, but the Office of Civil Rights can come knocking on our door, so to speak. It's not a court case or anything of that nature, but we certainly know as school officials we have to adhere to Office of Civil Rights. I love Title IX. It is about equity and access to an education. It has very little to do with equity in sports, although that's where it started, but it has been defined and redefined many, many times. For example, President Obama's administration just redefined Office of Civil Rights to include transgender students, so that transgender students, according to President Obama's administration and interpretation, had the right to use whatever bathroom the child identified with and whatever locker room. However, 12 states filed a lawsuit against the federal government, and a Texas federal judge and several others have followed also, have held this law in abeyance, this interpretation of Title IX in abeyance, until further court wrangling. So what we're back with trying to figure out as a district what we do about bathroom, locker rooms, etc. But Title IX will be our guide in this. Once these lawsuits are settled that all these states have filed, the states may prevail, or the interpretation under the current administration may prevail. But either way, we'll get some guidance, and we'll be able to know how to advocate with legal muscle for kids.
Perfect. We are at the top of the hour. Do you have a couple more minutes, Carolyn? If not, I understand you're dealing with this situation there with the hurricane, but if you have a couple minutes, I could do a couple more questions.
I do have a couple of minutes. I'm actually at one of our very best graduates. She opened her home to me and is allowing me to use her home for this webinar, because the traffic was so crazy I couldn't make it home, and UNF closed and kicked me out off campus. So thank goodness. A shout out to Beth Jenkins, Supervisor of Guidance in Duval County Public Schools and one of UNF's graduates.
Oh, that is wonderful. Well, thank you, or thank her on our behalf. Okay, a couple more questions. What are your thoughts on giving all students a universal mental health screener? Parent permission? Question mark. So should you seek parent permission as well?
You know, on the surface, doesn't that sound like a good idea? However, when you start picking it apart, it doesn't, off the cuff, I don't think this is a good idea. Why are we doing this? What kind of questions are included? Will it open a can of worms for a kid who may then not have some follow-up support? I'm just a big proponent of don't put something out there in mass to kids unless you've got a mass of people who can be there on a continuous basis to support those kids. So I'd have to know what the questions are, what kind of possible implications there could be for kids because it really is about protecting kids. It's not about some publisher has a great tool that they want to, blanket the nation with. It's really about what is the impact on kids and also on counselors' time. Folks will come into our schools and open up a lot of issues that then they leave a school counselor who's overburdened with 660 students for whom they're responsible, and we have to pick up the pieces. How is it going to be used, and what kind of support is going to be there if they identify kids who need support? Or is this something that we can put out there for the community to pick up and take on, so that the school is not required to be all things to all people?
All right, perfect. Let's see. I do not use a suicide assessment 5th and 6th grade. I contact parents with every threat. I fear the assessment will minimize seriousness. Is this a best practice?
I love that practice. A suicide assessment is really not something we want to use except to underscore severity. If you do an assessment and you know that a child has already tried, for example, or they have a plan, or they're in a high risk category, we love our suicide assessments to be able to say to parents, I think we should get the emergency medical technicians to transport this child to the hospital, because now we know. But what about that child like Nicole Eisel and the thousands of others who fooled us into thinking there was nothing to it? They fooled us because they wanted us to stop putting our gaze on them. I think we have to keep our gaze on any kid for whom it's been rumored until we get them safely in their parents' hands. And I think we need to tell their parents everything we know, and we need to use the right words. I've worked on a couple of cases involving suicide that went to litigation, and the problem was the counselor tried to use words that they thought would be less volatile, such as impulse control and things like that. Don't make the message softer. It needs to be, you put it out there. And I love the fact that you don't use them, you always call parents. If you decide not to use them, there's nothing wrong with using them if you use them in the right way to underscore severity, and to also call parents. Now, if the child denies everything and it's low risk, don't use the words low risk. Just call parents and tell them why you did a suicide assessment. Anytime you think it is necessary to do a suicide assessment, it is also necessary to call parents. No question asked. You wouldn't have done a suicide assessment unless something precipitated that. So don't second guess yourself. Don't feel like you have to be right or wrong. Call. Let parents intervene on behalf of their child. It's the right thing to do.
All right. If there were one sentence to use to get another school counselor, or to get other school counselors to click on a link to the new ethical standards in an email, what would you say?
It's your standard of care. You are operating, oh, you said one sentence. Okay, let me start over. Dear counselor, can I have a salutation? Is that all right? Dear counselor, you are operating outside your standard of care if you do not know your code of ethics and are a member of your professional organization.
Thank you. All right. I am curious if you can expand upon confidentiality with staff. We've had some questions at our school about what staff can and cannot have. Do you have guidelines on how to know how much to share with staff?
I don't have guidelines, but I just say I love the fact that our profession is just full of um, high-functioning people who are high on the personal social conscious continuum. I think what we need to keep in mind is what I call the need to know term. What does that teacher need to know in order to advantage the student? It's two professionals working on behalf of a little person who needs us. I say, tell them what they need to know, tell them no more than they need to know. It should never be where you start to feel like, uh-oh, I feel like I'm sensationalizing this a little bit. I feel like I'm embellishing it too much. Tell them what they need to know. If Cedric spent the night under the bed because his mom and dad were in domestic violence and the police called, and Cedric on a daily basis is a handful for a teacher, is that information that that teacher needs to know in order to advantage Cedric? You know, maybe Cedric's going to have to move. Maybe his whole little world has come crashing down. I think if it's an elementary kid, he's 8 years old, I'm going to be beating a path down to that teacher to say, Cedric needs your magic today. That is, if that teacher's high on the personal social consciousness continuum. If they're not, I might not say anything at all. If they're a middle school age kid or they're a mature elementary, I'm still going to ask their permission as to who they want to know. If they're high school, I'm absolutely going to ask their permission. But I think the need to know is something that the trusting relationship is not stepped on if it is two professionals trying to advantage a kid. And if it's developmentally, if this is something that you need to take the onus on your shoulders to keep this kid safe and they're not able to give you permission, such as a 7-year-old, if they are able to give you permission, don't say anything to anybody without asking the kid's permission. But again, it's judgment. Aren't we happy that we can exercise judgment and we don't have to go by some little box that we're in where we're constantly, our judgment has been taken away from us and we're constantly dictated what we need to do.
All right, thanks. For counselors in religious schools, does the non-referral process still apply? Can they choose not, it's cut off a little bit, not to counsel based off of beliefs, I'm assuming is what it's saying?
Did the first part say non-public schools?
Religious schools. It doesn't say.
Okay, religious schools. It's a whole different ballgame when you're in a parochial or private school. For example, if you're in a public school, Parker versus Hurley is a court case that said that these two parents in Massachusetts who wanted to keep their kids out of school counseling curriculum because it was about diversity training, all kinds of different families, one of which, one family was two males, two dads, and one was two females, two moms. The court said, no, you can't do that. You can send your kid to private school. That's your right. That's your constitutionally protected right. But as long as you're in public school, we don't have to ask you what the curriculum is. And no, we don't have to seek your permission, parents, curriculum. However, when you get over to private and public and parochial schools, it's a whole different ballgame. They can decide what the curriculum is and what you can say about, for example, controversial issues such as LGBTQ issues and abortion, etc. That's a whole different ballgame. When you take employment in a district or in a setting, you have to be willing to follow the tenets of that setting and act responsibly to change them if you believe they're stepping on kids' rights. It is not your right to take a job in a parochial school and then do your own thing. You have to adhere to the community standards, the institutional standards. But act responsibly to change those standards if you think they need to change.
Okay, a couple more if you have time. Help us understand how to help counselors understand that in addition to ASCA ethical standards, they also have a duty to abide by their state's code of ethics for educators. Can you?
I'm not sure how to, that's just basic. That's just basic. You have to abide by all your code of ethics. When you sign that contract said you're going to adhere to the state's ethical standards. You can't pick and choose which ethical standards you adhere to. You have to adhere to the ethical standards of the profession and also of your state's ethical standards. I'm not sure how to, I mean, that's just a non-negotiable. You don't get to decide whether or not you'll be ethical.
Okay.
If you do decide not to be ethical, then you're putting yourself at risk and your school district at risk.
Perfect. Should counselors have insurance?
Yes, you should join ASCA. ASCA has $1 million of liability insurance as part of your membership.
Okay. Our school district does not want to use the ASCA model. How do we practice? I'm not sure if that, I'm not exactly sure what that means, but perhaps how do they approach counseling if they don't, if the school district doesn't want them to use the model?
You know what I would do? I would get myself 3 goals every year and use the data piece of the ASCA national model. No school district in America is going to ever argue with the school counselor. Well, there's probably one out there that might, but generally speaking, every educator, especially principals, live and die by moving data. They don't get promoted because they, had the best paint job on their facade. They get promoted because of test scores, attendance, discipline, promotion, etc. Tie your role to what the ASCA model asks you to tie your role to, which is 3 goals each year. And there's nothing that says that you can't do that. I mean, that is the ethical imperative of the nation. That is the ethical imperative of the profession. So as people start to see the impact that school counselors can make when they have data-informed school practice, then the rest of the model can follow. Even if they never call it the ASCA national model, you can still operate with the tenets of the ASCA national model and be a powerful school counselor. Yeah, ideally, they would endorse and bless the ASCA national model, but a lot of districts, they do the same type of tenets of the ASCA national model, but they call it the, Georgia model or the Cobb County model or the Duval County model. That's okay. Just do what you know is the ethical right thing to do, and that is get yourself 3 data goals every year and drive those data goals in a positive direction, and everything under your umbrella for your comprehensive school counseling program ties back to those 3 data goals. I'd love to talk to whoever asked that question more about that because I think they might be between a rock and a hard place, and please reach out. cstone@unf.edu if you want to talk more about that.
Perfect. Will there be a 4th edition to the Ethics and Law book?
It is in the works. It has to be to the editor by February. so that it can be unrolled at the 2017 ASCA conference in Denver? So the answer to that is yes. I just have to get busy.
All right, and last question, and then we will leave you to it. All right, district-wide logging of notes on students is provided to all employees, and I only submit my contact for consult and then keep my sole possession of the notes. When admin asks for my notes and I decline, is that appropriate?
Okay, that is a big one, and that would take us much longer than a few minutes to answer.
Okay.
So there are lots of nuances to that, but let me just say that anything we maintain on a student is most likely an educational record. According to the Family Policy Compliance Office, it is almost impossible to meet the criteria of sole possession. Anything that is a maintained record on a student and that becomes an educational record, technically administrators have a right to it because of legitimate educational interest. The head of that school is the LEI for every kid in that school. So I would say it's going to take more political astuteness than, because there's not a whole lot of legal muscle to prevent that administrator from having those notes. I think our better approach is filter what we write through the lens that others might read it. And as a school counselor, it was a good week when I got down everybody's name that I saw that week and the date that I saw them, because the number of students we have, detailed, prolific notes is not something that we can accomplish very often anyway. So write what you need to, but filter it through the lens. If administration is pushing to have it, technically they can have it. And we have some guidance in that through the courts and also through FIPCO, Family Policy Compliance Office, that let us know if we write it down, it's an educational record. Sole possession record is almost impossible to meet that criteria. So be political. That's our best tool that we have in our little arsenal.
All right, thanks. And to end on a positive note, we have just one comment. The addition of the new section for site supervisors is so helpful. I used this section during my training for site supervisors this fall. So great feedback there. And that's it for the question. So I think we can go ahead and end it. I did want to note that there was the option to download the handout for the presentation, which was found under the handout tab there. If you want to quickly grab that, that would be good. And thank you, Carolyn, and thank you for joining us today for the 2016 webinar series. We will be posting this on our website as a reminder, schoolcounselor.org/webinar archive. And you can also take advantage of the CEU quiz once the webinar recording is posted. Also, please check out our upcoming webinars. We have quite a few lined up. We'd love for you to attend those as well. And thanks again, Carolyn.
Listen, it is my pleasure, Jen. Thank you so much for organizing all this and for putting up with my panic when I couldn't get to an internet connection.
That's
when I got kicked off my campus. Yeah.
All right. Thanks, Carolyn. Thank you, everyone.
All right. Thanks, everyone who tuned in.
All right.
Bye-bye.
Bye.